Hello, class, and welcome to Chapter 13, Offenses Against the Administration. In this chapter, we'll be talking about offenses against public administration, breaches of public trust, common law offenses, and offenses that were classified as misdemeanors. So if you look at breaches of public trust, they can lead to erosion of public trust, common law offenses of bribery, perjury, and subornation of perjury, resisting arrest, obstruction of justice, and compounding a crime and escape would all be considered common law offenses of offenses against public administration. The concept of criminal contempt is also important because it helps to maintain the authority of the court and respect for judicial officers. The crime of offering, giving, requesting, soliciting, or receiving something of value to influence the decision of a public official constitutes bribery. And bribery is one of those type of offenses where if you accept a gift, accept a bribe, you can equally be in trouble under the law. So especially if you're a public official, certain public officials can be convicted of corruption-related offenses for accepting bribes. But if you were to offer a bribe or give or request or solicit something of value, then you could equally be criminally culpable. Bribery is a felony under modern law. It's often associated with white-collar crime and organized crime. As we discussed, white-collar criminals are criminals that commit crimes within their legitimate business role. An example of this would be obtaining a government contract. So a practical example would be if I knew someone who worked in public government, and I know that the process is that local government is supposed to put out a bid for a certain type of contract, and if I have a friend in that office and I try to use my personal relationship with that friend to influence that contract decision, and I try to give the person who's making the decision some type of bribe, I offer them, give them something of value to give me the contract in lieu of someone else, then that could constitute a bribe. Prosecution must prove act and corrupt intent. So in the case of prosecution, they have to prove that I knowingly, willingly, and intentionally try to give this valued item to a person in exchange for some type of favor or service. So the only recognized defense to bribery is entrapment. So if you can show that you were solicited, you had no intention of committing a crime, but because someone had forced you into making this decision and it wasn't a crime that you were intending to commit anyway. Again, we talked about in criminal law the mens rea, the intent, how that's important to show that the person actually had the intent to commit a crime. So the only recognized defense of bribery in this case would be showing entrapment. Commercial and sports bribery. Commercial bribery includes certain corrupt practices within business, which could be fraudulent acts of purchasing agents. Sports bribery is the offer of anything of value to a participant or official in an amateur or professional athletic contest to vary his or her performance, which includes accepting bribes. You may hear about situations where referees have accepted bribes to officiate a game in a certain way that could significantly change the outcome. That would be an example of bribery having to do with sports. An example would be the 2002 Winter Olympics. In the figure skating competition, a panel of judges from different countries evaluate the performance of the athletes themselves. And during the Olympics, the French and Russian judges exchange bribes to ensure wins for their teams. So the Russian judges voted for the French ice dancers, and in return, the French judges voted for the Russian pairs. So when you think about this and the problems that are associated with sports bribery, we know that not only is it unethical, but it can also be illegal under certain circumstances. And there are other examples you probably have heard about when it comes to bribery of judges or bribery of officials to officiate games, or sports figures, sports athletes taking bribes to throw certain games to change the outcome of the game. An example of that would be point shaving. If you had, say, a basketball player who on average scored, say, 40 points a game, and because of sports betting, he may bet against his team. And in order to ensure victory for the other team, he may shave points in that he doesn't score at his maximum scoring potential to try to change the outcome of the game. And when you think about punishments, you think about what is appropriate for these type of offenses. It really just depends on the nature of the offense, who was involved, and what the damage was. The crime of perjury involves making a false statement under oath. And so if you're a witness in court, or if you sign a statement that you probably have seen this on certain job applications, especially if you're applying for a job with the federal government or state government or even local government, where it will ask you a question. Do you attest to the fact that the information you're providing is accurate and true under penalty of perjury? So what you're saying when you sign that statement is essentially that you could be charged with the crime of perjury if you lie on that application. So the prosecution must prove that the defendant took an oath and made a false statement while under oath. And there is a two-witness rule where the prosecution must prove that the falsity of the defendant's statement either with two witnesses, meaning two people had witnessed the act, or one witness and a corroborating documentation or evidence, which would in turn meet that two-witness rule. In the case United States versus Gaudin in 1995, the U.S. Supreme Court held that the materiality of the witness statement is in question for a jury. And Gaudin was on trial for making false statements to the Department of Housing and Development about loan documents. So the trial judge instructed the jury that the issue of materiality was a court matter, so the court had to decide whether it was a material issue, meaning that was the evidence of such a grave nature, did it make such an impact to show that, yes, it should count as a witness statement. So as we said under the two-witness rule, you either have to have two witnesses or you have one witness and you have the material evidence that proves that the person likely did it. So the Supreme Court disagreed and reversed Gaudin's conviction in this case. Making false statements is another criminal act. Federal statutes prohibit making false statements without taking an oath, so you wouldn't necessarily have to take an oath, as in the case of perjury. You can just make a false statement to a government official or to a law enforcement agent. So there is criticism about this because some would argue it is unfair for the government to prosecute someone merely for denial of wrongdoing, and the government cannot charge someone for refusing to talk to them. However, if you falsify evidence, if you make a statement that obstructs, you could be charged with obstruction of justice. So that's another facet of this. There are some defenses to perjury cases. Recantation, which would be like you recant your initial statement, you withdraw, or repudiation of previous statements, sometimes also possible when the person lied under oath. They may be able to recant. Sometimes they can, sometimes they can't. Nelson versus State in 1985, the court held that retraction of a false statement is a defense if the retraction occurs in the same proceeding and the statement is retracted before it becomes manifest that the fabrication is or will be exposed. So if a person, if they either lie or they misspeak or they make a statement that's questionable and they recant it and they try to change their statement, that is permissible under some circumstances within a certain time frame, but a person can't come back after the fact, especially if there's omission, which is another false statement. If you lie by omission, you essentially are not including all the information, so you're omitting certain information, which can also be considered lying in the case of a false statement. So an example of perjury, Roger Clemens was a famous baseball pitcher and was accused of using performance-enhancing drugs. At a congressional hearing in 2008, he lied about his use of steroids and human growth hormones to improve his performance, also called doping. He was tried for making false statements in perjury. The prosecution based its case mainly on one key witness, which was his doctor, Brian McNamee, and the prosecution did ask for a prison term. The jury found him not guilty in 2012. Obstruction of justice, as we talked about earlier, is the crime of impeding or preventing law enforcement or the administration of justice. So if you tamper with jurors or witnesses, if you provide false evidence, if you obstruct an officer from doing his or her job or investigation, you could be charged with an obstruction of justice. So there was actually a recent case in this by the FBI, and the FBI was investigating Lee Baca, who was the former sheriff of the Los Angeles County Sheriff's Department. And in this case, Lee Baca and his undersheriff, Paul Tancada, was given a 5-year sentence for tampering with one of his persons, his actual jail inmates, who was collecting information for the FBI regarding abuses of sheriff's officers in that area. So what ended up happening was Paul Tancada got a 5-year sentence. Sheriff Lee Baca, former Sheriff Lee Baca, is currently convicted but is awaiting sentencing. And so that's an example of how if you tamper with an investigation, which is what Tancada got arrested and jailed for, you can be facing some serious criminal consequences. So other examples include delaying or hindering the apprehension of persons sought by law enforcement. There is a duty for citizens to come to the assistance of law enforcement officers upon request, and if you fail to do so, it is possible you could get charged with obstruction of justice. Other examples, Casey Anthony was charged with murdering her 2-year-old daughter Kaylee, and Casey failed to file the report of her daughter being missing for several weeks, and Kaylee was found dead, her daughter, a few weeks later. The defense argued that Kaylee had accidentally drowned in the pool and that Casey was too afraid to report it to authorities. Could she be charged with obstruction of justice? The simple answer is yes. She had information. She had a duty to report. She didn't bring that information forward. She could have been charged, especially when she has a duty to report her missing child. So in this example, we're going to be talking about compounding a crime versus misprision of a felony. So in compounding a crime, the acceptance of money or something else of value in exchange for an agreement not to prosecute a person for committing a crime, it's a statutory crime. Okay, so compounding a crime, you can be charged with that. Misprision of felony is concealing the felony committed by another. So if someone commits a crime and you know about it and you don't report it, it is a statutory crime in most states. And states rely on statutes making it an offense to become an accessory after the fact to an offense. So it is a felony offense under federal law to conceal a felony of another. Escape from lawful confinement. So the unlawful fleeing to avoid arrest or confinement, it is punishable by an offense for escape. So punishment is more severe if the escape is forceful. The prosecutor must typically establish specific intent. So examples would include not returning to custody after furlough or temporary release. So oftentimes, if someone is furloughed from prison, meaning they're given a temporary release from prison, and they don't return at the time that they're required to come back, that's treated like an escape. Escaping from a detention facility obviously would constitute an escape, and we know we had an example of that in our local area here with Dannemora and the Clinton Correctional Facility escape. Defenses to escape charges, it could be unlawful confinement or custody, sometimes used by people who were in prison innocently, like in the case of State versus Dixon, in 1980. And duress or necessity. Duress dictates that you're being forced to do something against your will. So out of necessity, which could be to preserve your life, you're participating in an act that you normally wouldn't of your own free will or volition because you're being forced to. An example of this is People versus Lovercamp in 1974, where there was a specific threat of death. And the courts have not recognized inhumane conditions or a lack of medical treatment as a necessity defense. In the case of United States versus Bailey in 1980, the U.S. Supreme Court held that the defendant should have rendered to authorities as soon as the duress or necessity had happened. So, in the case of United States versus Bailey, Bailey and 3 other prisoners escaped from a prison by crawling through a window, and they argued that the conditions in the prison were intolerable and escape was necessary. The court upheld their conviction for escape. There are two main terms you need to be aware of: criminal contempt and civil contempt. In the case of criminal contempt, it's being held in contempt of court pending the performance of some court-ordered act. And the goal is to coerce the person to obey a court order. And an example would be failing to pay ordered child support. In the case of civil contempt, this involves a violation of a court order or otherwise intentionally interfering with the administration of the court. And they hold you in contempt when you otherwise embarrass the court by doing something that you are not representing the interests of the court well. Criminal contempt would be like if you fail to abide by something. Like if contempt of court for criminal, a good example of that would be if you fail to show up for a court date, they would issue a bench warrant, and that in turn is a consequence for not showing up for court. You also have the concepts of direct contempt versus indirect contempt. And direct contempt is an obstructive or insultive act committed by a person in the immediate presence of the court. An example would be disruption of the examination of a witness, usually handled summarily. And you have an indirect contempt, where an act committed outside the presence of a court that insults the court or obstructs a judicial proceeding. So this is more constructive contempt. And an example would be a juror who discusses the facts of a case with a news reporter. Oftentimes, judges will issue gag orders where jurors cannot speak to the press, and you could be held in contempt if you violated that judge's order. Proceedings are more formal in the case of indirect contempt. In the case of Satcher v. United States, 1952, the U.S. Supreme Court upheld the conviction of 11 lawyers of the Communist Party for violating the Smith Act. And the Smith Act prohibits acts with the goal to overthrow the U.S. government. The defendants were convicted for their persistent obstructive colloquies, objections, arguments, and many groundless charges against the court. Legislative contempt is an act of purposely impeding legislative activities. So examples would include failure to answer questions pertinent to the question under inquiry, failing to appear as a witness, refusal to produce requested documents. So those are common examples. The prosecutor must prove deliberate and intentional refusal. So this can't just be a mistake of fact or a mistake of understanding. They have to show that you willingly, purposefully, intentionally committed these acts. Watkins v. United States in 1957, the U.S. Supreme Court overturned the conviction of Watkins for failing to answer questions about the other suspected communists. So in this case, he was convicted for legislative contempt. So the U.S. Supreme Court overruled the conviction, stating that his due process rights were violated and that the court also was concerned about possible violations of Watkins's First Amendment rights. That concludes Chapter 13. Please feel free to contact me if you have any questions regarding this chapter. It's my pleasure working with all of you this semester. I hope you have a great final exam experience, and I hope to work with you again in the future. Have a great day.